If you could pull that up again, sorry, I missed that. CLBC Library.
Thank you very much. I can go to sleep now.
CLB at Gmail. Okay, that's very modern of you. CLBC Librarian. Okay, good. Should be going through. Anyway, so I need without a subject, so it may end up in your junk mail.
We don't use this account, but we need it for the
Yeah, for sure. Okay, I'm gonna just be a total pain.
Oh, there it is.
Oh, it is. Okay, good. Great, excellent. So I can put this away then, right? That's what you're saying?
Yeah.
Okay, I might just advance the slides with the clicker, right?
I'm gonna plug this in.
Oh, you're still got it. Beautiful.
Here, I'll put up my.
I'm not the authority on anything.
Gosh, I would hate to be late for you. You know that?
It's expensive for sure.
The thing will bother.
Yes. Limited USB
Yeah,
drivers.
you lots of time.
I might need
Don't
you-
worry.
Yeah.
I can use the. I can do it the
It's
old-fashioned
a
way.
wireless one.
No
Or
problem.
you can advance with the key and take it with you wherever you need to sort of
Just hold it
stand.
out.
What is the what's the sort of width of the camera? Where
Oh,
is
yeah.
Hey, Brandon.
The camera
It's sort of like ends about here.
Here-ish?
You can come here.
What if I stood over there so I'd be out of the way?
I'll show you.
And I'll make sure that this doesn't kill you.
Do you wanna see?
Come on in.
It's back.
Right,
This is
okay.
start to-
Sorry.
That is actually
Are we on mute?
Brandon's, I think.
Nope. Do you wanna
I'm
see the?
teasing. I'm teasing. It was just the mic. Depends on who you ask. Right?
Oh, okay. Yeah, I'll stay
If you're
within the
in,
boundaries.
It's 6 p.m.
All right, I'll behave.
Okay.
I try not to kill myself.
Well, we can open it up a little.
She likes to
No,
walk.
that's all good.
She likes to walk.
Although I'm happy if you want to zoom out. How's it going? Are you doctor now? Doctor Steve? Very close though. You're getting almost full.
I have. No, I can't.
Ontario? Ontario. Okay. Same
So
thing.
for folks that haven't been to the space before, there's washrooms just out the door, 2 stalls, and there's some water
Yeah, it was really fun.
cups and stuff in that lunchroom. Help yourself.
Like I have it on full volume.
How about the cookie? The French good.
Yeah, the cookies feel free. There aren't many, but you guys are early birds, so you get.
How about now? Is it any louder? Can you hear me? Is it louder?
Yeah, I'm the first time here. If you have a
Nikki, this is Andrew Hillier. Nikki,
How about now?
Yeah, I think so. So we have some.
Any better, Eric? Or Eric? Any better? Any better? Any better? Any better? Any better? Test, 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 test. Okay. It shouldn't be. Test, 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 test.
There's a guy who can hold very young, and then he's a
Is there a way to increase the?
Yeah.
and also RAY .ca. Go to his website. I forget .ca or .com.
Sandy, look at that.
Sandy.
That is nice. Look at that.
Obviously,
Yeah, so I read that one last library too,
Obviously
so
they're
we're
all
just
using
to make sure everything's.
To self-mock
So happy to have folks in
oh,
this.
we like this group. Usually the librarian we all the
Yeah, yeah. Books,
See if there's
online,
okay while we're.
tech, it's all part of it, so.
Okay.
Yeah, thank you for coming.
My pleasure.
What a phone call.
Sorry, my phone call.
I think we met at the very first one.
That's right.
Kristen Ogden.
to introduce our awesome speakers. So thanks.
All right. Thanks, Katrina. So my name's Brandon Hastings. Welcome. No worries. Welcome. We're going to have a really good session tonight. Today we're talking about AI expert systems and the BC Civil Resolution Tribunal. And we're going to be hearing from two amazing speakers, Shannon Salter and Lauren Kerr. We'll talk a little bit more about that later. The CRT, Civil Resolution Tribunal, for anybody who doesn't know, handles strata disputes and now small claims up to $5,000 in British Columbia. It's probably a world-leading platform, and it's probably, well, almost definitely the most access to justice-y sort of way of handling any dispute that I know of in British Columbia, for sure. I'm a lawyer at Key Law Center and a co-founder of Vancouver Legal Hackers. I sit on various boards related to A2J and write for magazines on legal futures and such things. My website's bhastings.com if you'd like to know more. And I'd like to take a moment to thank our sponsors, Courthouse Library, represented by the lovely Katrina Leung. So can we just put our hands together for Courthouse Library for having us today? Katrina is a co-working lawyer at Clio. She's a founder of Intuit Law and a liaison at Courthouse Libraries BC. I say that again because I'm not sure the audio stream was working when we did it at first. Courthouse Libraries, their mission is to help lawyers in the community find useful legal information. They have lots of cool free resources, 29 libraries across the province. I know I've used them both for access to legal resources that my firm was not paying for at that time, and also just to call the librarian to make sure I wasn't getting anything wrong. So thank you. So let's talk about social media and phones. So if everybody could silence your phones, if you haven't done that already. And I just want to say a few things about social media. So the Twitter is Legal Hackers Van. That's our Twitter, at Legal Hackers Van. The hashtag for tonight's event, CRT VLH, all one thing. And photos are welcome. I'm going to probably read out the best tweet at the end of the night, / maybe I'll put up props for whoever the best tweeter was on our page that will stay there until the next event. Vancouver Legal Hackers, we founded this organization last year in 2016, and it's experienced some pretty cool growth. So we've gone from 0 people last year to 433 members now. It's part of a global organization. Legal Hackers internationally has membership in 50 countries, and every continent except Antarctica and Australia. So I don't know why A's, I guess, are repellent. The Legal Hackers mission statement is that it's a global movement of lawyers, policymakers, and technologists who explore and develop creative solutions to some of the most pressing issues at the intersection of law and technology. Through meetups, hackathons, and workshops, Legal Hackers spot issues and opportunities where technology can improve and inform the practice of law, legal practice, and policy to adapt rapidly to changing technology. So one more piece of business before we get on to the main program, and that is we're a fairly new organization. None of the co-founders are professional event organizers, so we have a couple things that I want to ask the people here tonight and also the people online. So the first thing is we are looking for sponsors. Space sponsors are great. Anybody that wants to provide food or drinks for meetups is awesome. My favorite type of sponsor to get would be somebody who gives us money, because right now the Legal Hackers fees go right onto our various credit cards. We're also thinking about doing a couple events, which I'd like people's feedback on. We're thinking about doing a coffee social, maybe once a month somewhere. Is anybody interested in that? Put up your hand if you might come out to something like that. Yeah, okay, that's a lot of people.
Sorry, excuse me, is the social meeting in Vancouver or where?
Let's start with probably in Vancouver somewhere, and it would just be I just want to sort of gauge the general interest. So it seems like we have a lot of people that were interested in that. The other thing we're thinking about doing is doing an event with one of our sister clubs in Washington. Is that something anybody would be interested in doing? Yeah, a couple people, hands, anybody? Okay, sounds reasonably interesting to people. And I'm going to leave the rest to this, but I did start a suggestion thread on the meetup group, so if you have any ideas and you want to put them forward, you can go in the meetup group, click on the discussion thing in the top. You'll see the suggestion thread, just add stuff in there, and we'll take a look at that and see if there's kind of anything that we think is doable for us. And before we move on, I just want to say thank you all for coming out. This is something that's really cool and I think really important. Access to justice is a big deal, and technology is a big piece that can help improve access to justice. So I just want to say thank you for coming out, and let's give everybody a round of applause for coming out and making this a thing. Good. So with that, I'm pleased to introduce the main event of the evening. Shannon Salter and Lauren Kerr are going to be presenting, as I said. I have some detailed bios to read out. So Shannon Salter received her LLB from UBC and her LLM from University of Toronto. She's formerly a clerk of the BC Supreme Court, a lawyer at Ferris, which one of our co-founders now works at, Vice Chair of the Workers' Compensation Appeal Tribunal, Vice President of the British Columbia Council of Administrative Tribunals. Currently, she sits as Commissioner of the Financial Institutions Commission, a board member at Canley, which is pretty cool, an adjunct professor at UBC Law, and of course the chair of the Civil Resolutions Tribunal, which is why you're here tonight. The CRT is Canada's first online tribunal, as we've talked about, and so I'm really looking forward to hearing about that. And you can follow her on Twitter at Shannon Salter. Lauren Kerr is she received her Juris Doctorate from the University of Victoria. She's an alumni of UBC Law, or UVic's Legal Information Technology class, along with one of the co-founders here, Mark McCamey. So they both actually took a class from Darren Thompson, who is he works for the Ministry of Justice and is in charge of some big chunk of the CRT, which I'm not entirely sure.
Critical to the implementation of the CRT.
Okay.
All different aspects of it, but particularly the Solution Explorer, which is what Lauren is going to be talking about later.
Okay, great. So there you go. And in 2017, Lauren Kerr is going to teach a course from TRU at University of Ottawa in knowledge engineering. My notes are messed up on that thing. She's previously worked for the City of Victoria, the BC Ministry of Justice, and has been a lawyer at Crease Harman LLP. She's a board member of the Justice Education Society of BC, an innovation advisor to the BC provincial government as a knowledge engineer, and that's what brings her today. So my understanding is that Ms. Salter is going to give us sort of a background in what CRT is, what it does, how it works, why it's important, and then Lauren is going to give us sort of a deep dive or like a nitty-gritty as to what it does, how it works, what the Solutions Explorer is, how this whole AI thing plays into it, and all that business. So I think with that, we'll ask Shannon Salter to come up and start talking to us.
Thank you very much. All right, I'm going to try not to kill myself on any chords. I'm going to arrange the keyboard right here, say hello to our online audience. Am I in the right space here?
Yes, that's perfect.
Great. Hi, everyone, and thanks everyone who came out today as well. So as Brendan said, I'm going to give you just kind of an overview of the CRT. My apologies to those of you who might have seen a slide or two of these before. Lauren is going to take you behind the scenes of the Solution Explorer. So I'll be talking about it really from a tribunal perspective and the user's perspective. She'll be talking about it by peeling back the other layers and really getting into how it was created. And spoiler, it was created by virtue of thousands of hours of human time. So, Lauren, are you there on the audio line?
I am, yes.
Okay, great. So I haven't said anything wrong yet so far, I hope.
No,
okay.
you're doing great.
Okay, there we go. All right. So as Brendan said, the CRT gets a lot of attention for being online. It's the first online tribunal in Canada. And one of the things that makes it unique in the ODR context is it's the first example that we know of ODR being used in a publicly integrated justice system context. So there are a lot of ODR platforms that are for-profit companies that have created them. So an example of that is Modria, which created the software for PayPal and eBay's dispute resolution centers. That's an example of a for-profit model. There are also non-profit models as well, like RecVisor 2.0, for example, which unfortunately has met a bit of a demise, but is being reconfigured, we hope, into something even better. And MyLaw BC is an example of the Legal Services Society using online dispute resolution, but not in an integrated sense. And so my strong bias is that ODR really can't reach its full potential in terms of delivering access to justice without being fully integrated into the public justice system. That's not to say there aren't roles for ODR in the private resolution of disputes, but I think until you incorporate ODR into the public justice system, you can't really force the public justice system to evolve in the way that it needs to. There's also some real dangers, I think, and this is I'm going to try not to get off on a rant, but there is a real danger in the fact that people are increasingly opting out of the public justice system. We talk about the vanishing trial. We know that claims year over year are going down. We know that people are not considering the public justice system as an accessible forum for the resolution of their disputes. Increasingly, though, they are going to other forums to resolve their dispute, things like eBay, things like PayPal. There's a billion startups to resolve low-level disputes, often trans-border disputes, online in a low-cost way. That's great, but the risk there is that those for-profit companies or even non-profit companies don't have to make sure that everybody can access their services. They can pick their market. They can segment their market. They can decide that they're only going to target people with a certain set of abilities. And so if we make that the default, if we create this essentially this black market for dispute resolution, and I don't mean that as pejoratively as it sounds, I worry that we're going to increasingly make the public justice system irrelevant and increasingly inaccessible for people who would otherwise fall through the cracks. So it's the fact that public justice entities like the CRT are forced, rightly, to consider that 100% of people are their market. They have to account for everybody. That I think is what holds so much potential for access to justice. So that's a mini rant about this part of the justice system component here. So yes, we are the first thing of its kind in Canada. As far as we know of, we're the first thing of its kind in the world. There is a program in Utah, of all places, that is well on its way to implementing ODR for small claims in a court context. There are other jurisdictions where government approval has been reached, for example, in the United Kingdom, but implementation work hasn't really quite begun in earnest. Similarly, in New South Wales, there is government approval for an ODR program integrated into their state administrative tribunals, but that's new. That happened only a month or two ago, and they haven't yet started to build. So it's exciting, and we are target number one for who do you talk to when you're trying to build these things, which reminds us that there really isn't a template to follow, and so we've kind of had the blessing and the curse of the blank slate in this context. I'm not quite as excited about the fact that the CRT is online as I am about the fact that you can use technology to achieve this underlying greater goal. The underlying greater goal is capitalizing on this opportunity to build this little corner of the justice system around the public, to go to where people are, take people within their context. The context can include families or jobs, and also a certain set of capabilities and also challenges. And so you can use technology to leverage the ability to go to where people are. But it's not the only way that you do that. But still, if you're trying to go to where people are today, overwhelmingly people are online. So it's a pretty good starting point. So really briefly, in terms of our jurisdiction, we have two main areas of jurisdiction, as Brendan mentioned. We've been handling condominium disputes in BC since July of last year, so almost a year. Before July of last year, you had to go to the BC Supreme Court for all of these types of disputes, which was not a particularly accessible place to go if you were arguing over a pet in your condominium unit, for example. As a result, not a lot of condominium disputes were going to the court. But since we opened last year, about 450 of them have now come to the CRT. As of 14 days ago, we also have jurisdiction over small claims below, $5,000 and under. I know that slide there says $25,000, but that's because the statutory framework allows for us to go up to $25,000 eventually. The thing to know about small claims, though, is that they are highly concentrated at the lower end of the monetary threshold. So claims under $5,000 represent about 40% of the small claims case volume last year. On the upper end, there's very, very few cases. So starting out with claims $5,000 and below is actually a pretty big step, and we want to make sure we get that right before we start raising that limit. So small claims, again, are these everyday legal problems that arise in people's lives, and they're much more disparate than condominium claims, and the only thing they have in common is that they are under $5,000. And I expect that Lauren may touch on some of the challenges in creating knowledge engineering and guided pathway systems in such disparate areas of the law. And if she doesn't, then you can ask her about that, because Lauren has been very much involved in the effort to create a lot of the content for small claims. So really briefly, touching on the access to justice crisis, this is why the CRT exists. I get asked a lot why the government didn't just roll condominium claims into the provincial court, for example. And I think the answer is that it represented a real opportunity to try something completely different. And while condominium disputes and small claims disputes are certainly very important to the people involved in them, they don't tend to be life and death issues. Nobody's going to prison, nobody's losing their children. And so they're an area where there's a high degree of complexity sometimes, and frustration and delay and cost, but the risks are lower in this area if you're going to try something new. And so we know that there are access barriers across the country. These barriers are the same really everywhere I travel in the world, but BC is no different. So particularly for rural folks, we hear from them all the time about how hard it is to actually get to a courthouse, how inaccessible it is to find a lawyer or mediator. We know that the complexity, particularly of strata disputes, is high. I won't get into how many sections strata property acts and subsections and that sort of thing, but it's a complicated area of the law. And the thing about small claims too is that even though they seem small because of the dollar amount is not a great proxy for complexity either. I used to see this all the time at WCAD. You would have a multi-million or a $1 million pension claim, say, that would turn on a pretty easy point of law. And then the next day you'd have a receipt for a massage therapy receipt for $80, and it involved the limitation period and a number of statutes and all kinds of legal interpretations. So the long and the short of it is these are hard issues sometimes, and there's very little support for people. There's no legal aid in these areas. We know about the delays in all levels of court. We know the cost for people, not just in terms of lawyers and limited ADR, limited alternative dispute resolution. And so things like mediation or facilitation are often treated as a bit of a sideline in our justice system. So pretty much everything we do from the time we file our claim onward is all geared towards the assumption you're going to have a trial date, your day in court. So pleadings that are framed adversarially, discovery, interrogatories, case conferences, all of that is based on this idea they're going to trial. And we know that's wrong 98% of the time on average. We treat mediation when it happens as a bit of a sideline or a speed bump on the way to that day in court. It's not central to our justice system. And in some ways we treat it very casually, or like it's a subservient, lesser form of justice.
ICBC accident would be some kind of
ICBC claims would be within our jurisdiction if they're $5,000 or under. And as I'll show you, we do focus very much on ADR. But our first starting point was, and sorry, let me know if I need to repeat questions for the online audience. I'm happy to do that. So our first starting point was not assuming that we actually know what the public wants. So if you're going to build something around the public, it makes sense to go out and ask them what matters to them, what are they doing? And firstly, we wanted to challenge this assumption we had that online was going to be a better way to serve people. And what we found through what is a landline-based survey, I assure you, and not just an online survey, balanced by age and geography and education, is that 92% of people are online daily in BC. 69% of people over the age of 74 are online every day. But about 3 to 5% of people don't use the internet at all. And so we have to be mindful of them as well. But if you ask people what they're doing, nobody's hacking the US election, for example. Nobody's doing incredibly complex coding, or at least maybe some people are, but not the bulk of the people who are answering the survey. What they were doing, though, is things like online banking. So 80% of us do online banking. We're really good at Googling stuff, buying stuff, social media, email, and texting. And so if you design technology that looks roughly like those things, you're already in an area where people are more comfortable, where they feel that there's less barriers or complexity for them. The other message we got loud and clear from this is that people don't want a judge or a tribunal member like me telling them what the outcome's going to be. They want a say in shaping their own resolution. And this is consistent with a lot of research on mediation too that shows that people are more likely to actually fulfill an agreement that they've reached consensually versus one that's been imposed upon them. 87% of people didn't want to have full legal representation. They wanted to do it themselves, likely due to cost. And then lastly, 81% of people gave us a vote of confidence that they would use something like this, even though at this point the CRT didn't quite exist yet. So we took that feedback along with all kinds of other feedback and created some guiding principles. Some of that other feedback came from organizations like PovNet, which organized some focus groups for us around the province, as well as operated, frankly, as a conduit to other advocates, as well as relationships we built with advocates. We've done all kinds of user testing. We've had a number of town hall meetings where 200 to 300 people will show up at the Italian Cultural Center on a Wednesday night. We have surveys, we get public emails, and we've taken all of this feedback and we have some core principles that drive everything we do. If you're going to build something around the public, whether it's technology or any other business process, you have to get people through it quickly, because there's good research to show that people feel, rightly or wrongly, that the longer they have a civil claim, the more it hurts their health. So a startling number of people can actually attribute a physical ailment to their civil claim. And there's research out of the Canadian Centre for Civil Justice on that. So it doesn't really matter, in my view, whether that's subjective or right or wrong, because people think that the justice system is bad for them. And that's not the fault of any particular person in the justice system, but they think that the fact of having the claim and dealing with the claim is harmful to them. So moving people through the process quickly saves their physical and or helps their physical and mental health, as well as their financial well-being. Now, we're not at that 60 to 90 day timeline yet. We probably won't get there for another year, but it is what we're driving towards, and it's one of the things we're measuring ourselves against. We're offering a range of alternative dispute resolution options. So we start with free and very little time and effort, and we increase the time and effort required as you get further into the claim. But we front load resources to try and help you get through the process quickly. We also are trying to maintain our own flexibility through user testing, because there's a real danger with a project like this that you can get too attached to one idea of how you're going to do something. And the good thing about public testing is that it keeps you pretty honest and humble, because the public will tell you very clearly if you've gotten something wrong. The front end of the CRT is free to use anywhere in the province. We're open 24 hours a day, and not surprisingly, about 45% of people are filing their applications outside of typical court hours. So mostly weekday evenings, weekends. Again, not a surprising statistic if you think about your own life and when you have time to do stuff, but it is helpful to have evidence on this point. There's a lack of evidence generally in our justice system, a lack of data. I see Andrew nodding because no doubt in his research he's encountered that firsthand. So we do, as a general point, want to be very transparent about the evidence we collect. We'll be reporting out on that, and I'm frequently contacted by academics who are asking if we have data yet. So I hope to provide that soon. The cost is roughly what small claims court costs, but we have what I think to be the easiest to use and hopefully most generous fee waiver program of any tribunal or court that I know of, and that was developed with advocates. So what we did is sent out an email to advocates saying, here are our assumptions. We assume that there's not going to be a lot of abuse of fee waivers, and 2, we assume that barriers to access to justice intersect. And so having to go to a bank or a ministry or a tax authority to collect documents to prove that you are low income is potentially creating more barriers than just paying the fee itself. So on that basis, if you go to our fee waiver form and you click that you're on a government assistance program, or you enter your household income if you're not on a government assistance program, and then click that that's true, you get your fee waiver right away. We're focused on efficiency in order to get people through this process quickly, but that's an area where analytics is going to be really helpful to us, and machine learning will be very helpful. We'll learn what types of disputes resolve most quickly through what pathways and through which kinds of techniques and approaches. We also try and avoid duplication for people, again, because we know that roughly half of adults in Canada with post-secondary educations can't complete government forms correctly. I fall into that category. I see Dom nodding. So you can imagine that for people who have literacy issues or don't speak English as a first language or don't have that level of education, it's a real problem to be asked to fill out forms to take every step in the life of your justice claim. And those forms are not designed primarily with users in mind. They're designed to meet the business needs of the tribunal or court, generally speaking. They're not typically user tested with the public. So this is what I mean when I say we're trying to flip this model. We're trying to get these disputes resolved as early, as inexpensively, and as easily as possible. The first box there is the Solution Explorer, and I'll show you a bit of that, and that's what Lauren's going to really get into more detail on. If that doesn't work to help people resolve their dispute, they can seamlessly file an application. They exchange documents with the other side, they serve the other side, and then the case is moved into facilitation, where one of our mediators helps the parties to achieve a resolution. If they can agree, that agreement is turned into a tribunal order, which is also an enforceable court order after the appeal period ends. We treat adjudication as a necessary last resort, but our basic assumption is that with proper support and expertise, you're likely to be able to resolve your dispute earlier on in terms that are going to be easier for you to live with, because they'll be tailored to what your interests are. So we are predominantly online, but we do offer mail and telephone-based services for folks who don't have access or ability to use the internet or email. What we found, though, and this is surprising to us too, is that despite having built out quite a lot of pathways for people who aren't online, so for example, you can go to any of the 62 Service BC counters in BC and get in-person service for CRT issues. You can also use mail or telephone. What we found is that since we opened for small claims, we've had 100 cases roughly, and only 2 of those have been through paper forms. With the strata cases, for example, we've only had 3 people request to use email, and this is out of about close to 1,000 parties, so roughly 450 cases, but about 1,000 participants. Strata is not a really great proxy for how generally people will choose to engage with the CRT, but early days in small claims is showing that there is a very high demand for online services. So our paper forms aren't going anywhere, our telephone lines aren't going anywhere, but it does validate the idea that most people, when given the choice, would prefer to move faster through an online process. And that's important because the digital divide issue and worrying about people who are not online, which you have to do, can become, though, an excuse for not doing anything else, for only using paper forms, for only doing things the way you have before. And I guess my point is that they're not mutually exclusive. You can provide, it's about providing choice and flexibility to people so that you can meet their needs. Okay, so the Solution Explorer, I'll be very brief on these things because Lauren will go into it again, but it is a guided pathway system, and this audience uniquely probably doesn't need me to explain what a guided pathway system is, which is pretty cool. But for other folks, I just explained that it's an interactive question and answer system that lets you give more targeted bits of plain language information to people. And you do that because when you ask people questions, you can really narrow in on what their issue is, and also provide them with opportunities to resolve their dispute through things like template letters. So we've subjected this beast to about 7 or 8 rounds of user testing, all different kinds of user testing. One of the most valuable kinds that we've done is recruiting members of the public just to sit down on the computer and then with their consent, watching what they do. So it's observational user testing. And that has been eye-opening for our team because all kinds of things that we thought were amazing as a group of lawyers and IT professionals in a boardroom together turned out to be total duds, and we've had to make changes. The other thing that we've learned through early user testing is that it's really important before you do any kind of coding to always start with the most vulnerable users. So a few things. Don't trust that lawyers and IT folks are a good proxy for public behavior because we have in common the idea that we tend to be pretty linear thinkers. So if A, then B. If B, well then either C or D. And it turns out through our testing that people with problems tend to just rush in and just click through everything until they get to the piece of information they think is vulnerable. And it doesn't matter if they've gone past the limitation period information and other stuff. So we used to have all kinds of very, in retrospect, paternalistic things like a pop-up box that would come up if you tried to go back saying, are you sure you want to change the course of your exploration? In other words, do you really know what's best for you? Like, I kind of cringe when I think about it now, but we only really tweaked onto that when we were doing this observational testing. It's one thing. So there was a lot of little mini failures along the way I could talk about, and I do like to talk about because part of my goal is to normalize this idea of incremental failures in the justice system. We're very frightened of that as legal actors. So I think it's important though, because you can either have all these little failures and little tweaks along the way when it's cheap and easy to change, or you can have a massive IT failure at the end in 2 years. So that was what I was always worried about at 3 a.m. So the combination of general user testing, but also starting that user testing with advocates has been really crucial. So we always start all of our user testing whenever we can, whether it's about a form or fees or technology or the rule. We try to start with advocates first, try to account for the needs of their clients. We can't always do that, but that's where we start. We typically make all kinds of changes as a result of that. Then we move on to mainstream public testing where people bless them in exchange for a gift card will volunteer to fill out a form for you and let you interview them. And I'm always amazed because you give me enough gift cards in the world to fill out another form in my life, but I really do value that. And so with all of our forms, we've done things like ask people, well, what did you find difficult to understand? What was confusing? What do you wish we had asked you? And that's led to a lot more changes as well. So that process takes a bit of time, but it's really valuable and it's not very expensive. It just requires a bit of time in the organization. So anyway, that aside, back to the Solution Explorer. This slide is really just to show you that it works on a smartphone. That's all. It uses responsive design. You don't need to download any special apps. We know again from advocates that they tell us that is really important for something to look good on a smartphone because that's the piece of technology their clients are most likely to have, less likely to have laptops or desktops. So it just needs to look good. It is necessary that you don't have to go to an app store to download anything. You should just be able to Google small claim BC and then get to the right place and be able to navigate easily. So this is where you access the Solution Explorer. It's on our website. Feel free to play along if you'd like. You don't have to have a login or anything like that. You don't have to have a CRT case. It's just there to provide free legal information. And we don't collect any personal information during the Solution Explorer phase. So these are just a couple of screenshots of what this looks like to give you a general idea. It's very truncated, but these are the most common strata problems people have. And we know that because that's what experts tell us, which Lauren will get into more detail on that, I think. If somebody's issue is not here, though, they can click that tell us what's missing button. And that information goes into what we call the treasure trove, where our team every 2 weeks reviews feedback that we get from that, feedback we get in different places in the technology, feedback from our frontline staff, from public emails, from stuff people are just hearing, from things our other staff members have noticed. And we review all of that feedback every 2 weeks and then prioritize changes so that we can change in an agile way. So we ask questions, we provide plain language legal information. We target a grade 6 to 8 reading level for everything that we write. We're probably not there 100% of the time, but that's the goal. So another way people can provide feedback here, they can rate the resource using the 5-star rating system. They can hit that very cathartic, angry, not helpful button. And so if this resource is getting a lot of angry red button clicks and half a star, then we know there's a problem, and we can act quickly to either replace the resource, revise it, change it, and that's a commitment we've made. So again, asking questions, as we show people resources, they stack up on the left-hand side. Again, that comes from user testing, that people like to jump around. There's a progress bar there. There's an access code, so if someone has to stop and make dinner, they can pick up again if they want to. And that's where we get to the most popular tool in the Solution Explorer, which is a template letter. Again, this is pretty truncated. So the idea is you give people information, you ask them questions, you give them information, and then you give them choices about what to do next. So that might look like writing a letter to someone who owes you money, or writing a letter suggesting a repayment plan to somebody you owe money, asking for a hearing from your strata council. And oftentimes people are really intimidated by writing these letters. They don't feel like they have the knowledge or the legal expertise to do it. So we've written it for them. And all they have to do is plug in their information, but they can also rewrite it if they don't like the way we've put things. But we've already put in the legislation, we've put in the deadlines that apply. And it's an in-text editor, so you don't need Word or any kind of software. You can do this from a public library and email it yourself or download it or print it. This is at the letter stages where most people drop off. Most people take their letter, they print it, and they go. So we have a huge drop off after the letter. But for the folks who have tried the letter or don't want to send it right then, they get to the summary report, which again provides links to all of the resources. And a person at this point can scroll down on this page and actually start their claim. And that leads seamlessly into the application form. The good thing about that is at that point we do start collecting information. We know that the person is a strata owner and we take them to that form. Or we know that they have a small claim under $3,000 and we take them to that form, which eliminates one more choice they have to make. Really briefly, this is what our form looks like. And I know I'm inordinately proud of the form, and so I force everybody to look at the glory that is this form. But this form is the result of feedback from a bunch of advocates, a bunch of members of the public, and also lawyers. We do test with the lawyers too, but we just do that last. Because the assumption is if it works for everybody else, it's likely also going to be working for lawyers. So as a result of this, we don't actually get a lot of staff questions about the form. And what that means is that our staff are not busy doing data entry for forms. They're also not answering questions about what does your, what is this obscure term refer to? What piece of information do you want? Instead, what that frees our staff up to do is help people who would otherwise fall through the cracks. And so I'll get to that on the next screen here. We ask questions in the form that are optional, but let people tell us if they need any special accommodation. And this really helps to humanize, I think, a process that, whether it's online or not, can seem pretty detached for folks. So it's optional, it's not information that goes to the respondent, but we ask people if they have literacy issues, a visual or hearing impairment, a mental health issue, anything else they want us to know about. And what happens then is our staff, who are not busy doing data entry, will, for instance, call somebody who's indicated they have a visual impairment. And they'll ask them questions like, what kinds of support do you have in place? Do you have any specialized equipment on your computer? Would you prefer, is there a way that we can communicate with you that's better? And oftentimes that's as simple as, for example, having a telephone mediation or an oral hearing instead of relying so much on written material. And maybe that's the opposite for somebody who has a hearing impairment. So we can't always do everything, but we think it's worth asking, and even trying to inquire seems to, and making the effort to ask seems to reduce people's anxiety about participating in the process. We also ask a couple of questions that are not really strictly legal questions, in the sense that they don't get at people's legal rights all the time anyway. Questions like, what have you done so far to try and resolve this? And why is resolving this claim important to you? And that's meant to assist the facilitation phase. So if the facilitator knows that the parties have already tried 10 different things, then they know where to start. They can take the temperature of the claim. If the facilitator and the respondents know that underlying this issue that appears to be about a $300 bylaw fine is really the fact that my name has been in the strata minutes and I feel humiliated and I'm really embarrassed every time I see somebody at the mailbox and I don't think it's fair, well, those are a different set of interests. It's not so much about the $300 maybe. And that's helpful information for the facilitator. So this negotiation phase is pretty cursory right now. We basically just encourage the parties to negotiate after they've served documents on each other. Where our next step is to build out the technology to create essentially a chat room where we can create a neutral virtual place for people to go if they want to start discussing their claim before a facilitator gets involved. And I think this might be helpful in debt claims particularly, where parties know that there's a process ahead of them, that one way or the other, likely an order might be coming their way. And so there might be an incentive to use this to work out a payment plan and avoid any further interaction with the CRT. But we'll see over time how effective that is. Mostly though, people need help at this stage, and that's why we have facilitators. We currently have 9 of them. We'll be hiring more in the next few months, and they are humans, not algorithms. I get asked that a lot, who have dispute resolution expertise. They've also, as with all of our staff, have undergone training in mental health issues, Indigenous cultural competency generally, as well as having difficult conversations with distraught people. And the approach here is very flexible. They will conduct the mediation or the facilitation through whatever means the parties want. If you have one person who's comfortable on the phone but not using the internet, then you go to the lowest common technological denominator. You have a telephone conference call. On the other hand, if you have somebody who has a day job, might be a single parent who has kids and can't take an hour off in the middle of the day, and they're in a dispute with a shift worker who has a totally different schedule, then maybe communicating by email is better for them as well. And so it's a very flexible process. And at the end of that process, you can either get an order from the tribunal, a consent resolution order capturing that agreement. That's enforceable as a court order. If the parties can't agree, then the role of the facilitator changes, and their job is to create a paint by numbers process for the parties to follow in exchanging their evidence and submissions to prepare them for the adjudication phase, where a tribunal member will make a decision on the legal merits. Everything that happens in the facilitation phase is treated as confidential vis-a-vis the tribunal member. We want to encourage people to take positions that they may not take if they were having an adjudicator decide their legal rights. So what goes to the adjudicator is the parties' submissions and their evidence, and we try and make that fairly simple to provide to us. And then again, last but not least, adjudication, very much like other tribunals in the province, except for a couple of things. One is that we predominantly have written hearings, although a number of tribunals do that too. Those hearings can be converted to oral hearings if there's credibility issues. The other reasons I've in the past converted something to an oral hearing, not at the CRT but in other tribunals, is if just looking at the submissions it's clear that the parties aren't able to represent themselves adequately in writing. That it might be beneficial to have an interpreter, for example, or just to hear from them directly. So that's another reason you might convert something to an oral hearing. I should say we have free telephone interpretation at all phases of the tribunal, right from the resolution support clerks to the adjudication phase. Free telephone interpretation in over 200 languages, including several Indigenous languages as well. So we're trying to get the word out about that. I've done a fair bit of work with Chinese language media, which has been very interested in this, which is great, to let people know there's different ways to communicate with us. People are also welcome to have a trusted friend or family member help them. We don't have anything kind of like the Mackenzie friend in terms of limitation or restrictions. As long as it's somebody that they trust, you can get help from whomever you please. There is a presumption of self-representation in the tribunal, and that's in our act. But we try to create a clear distinction between helpers and representatives. So helpers can do all kinds of things. You can have legal advice from a lawyer, and that's fine. You don't need permission for that. You can have the lawyer fill out your submissions, fill out your form, wrangle together your evidence, give you advice on mediation. It's only when you want someone to speak for you, you don't want to do any of the talking yourself, that's when you would need permission from the tribunal. There's some exceptions, so if you're a minor or somebody with impaired mental capacity, you don't need the tribunal's permission. And there is a discretionary category. So if it's in the interest of fairness or justice, the tribunal can also give somebody permission to have a representative. And I should say that that's been pretty controversial among lawyers. It has been much less controversial among members of the public. So in these town hall meetings, the 200 or 300 people on the Wednesday night at the community center, I've never once had a member of the public express concern about that. Overwhelmingly, what they express is a sense of relief. And that was a bit surprising to me as a lawyer, even a lawyer who prided herself on being access to justice minded. I underestimated the kind of gulf between what the legal profession's view or expectation of public need is versus what the public is actually saying about that. And I also underestimated how much people really feel like the cards are stacked against them if they're up against a lawyer. So anyway, that's more food for thought, I think, for the legal profession generally at a time when the profession is grappling with some of these issues. But in any event, so far that's worked pretty well. Where we get pushback is when we actually allow a representative. And typically the other party will send us a fairly upset email asking why we've exercised our discretion in that way. So our written reasons are on our website. If you're interested, they're meant to be plain language. We're lucky to have some excellent senior tribunal members across the province. We have 16 part-time members, 3 full-time members, including me, and they've all gone through a boot camp. In addition to the training I described for the staff, they've done that training too, for the most part. They also have gone through plain language writing, de-lawyering their writing, which I've struggled with as well, so I feel that pain. And I don't think we're quite there yet, but we are aiming for our decisions again to be at that grade 6 to 8 reading level. It's hard. I did a decision a couple of weeks ago on res judicata and issue estoppel. It's really hard to write that at a grade 6 level and still use those terms, but you kind of have to because that's what the case law all says that you're later referring to. So all to say, it's a work in progress. Our decisions are going to be published on Canly in the next couple of weeks, but in the meantime, and well, this will continue after we're publishing the decisions on Canly, but our decisions are published on the website using a product called Decisia from Lexham. That's the same publishing software that fuels Canly and also the Supreme Court of Canada's decisions, the Federal Court of Appeal, and that sort of thing. It was really important to have a transparent, rigorous way to search our decisions. I think this is part of accountability. It's really hard to know what the tribunal is doing or what their decision-making process is if you can only kind of click on one decision at a time. Somebody should be able to search and see if Salter decides 90% of the time one way or the other. And you can't really do that unless you have a really robust database. Okay, really briefly, we have an appeal method, of course, because tribunals are never the last word on anything. There's basically an unfettered right of appeal to the small claims court, but there are cost and deposit consequences if you go that route. On the strata side, it's much more limited. You need leave to appeal, and if it is granted, an appeal lies only on a question of law. So we've had one case where leave has been granted and the appeal has not been heard yet. We're only 10 days into small claims, so we haven't had the chance to have any cases go to the small claims court yet, but I'm sure that will happen at some point. So this is a look at our caseload at a glance. We've had a massive number of people go through the Solution Explorer, and then less than 10% of those people have started a claim. And so the temptation, as somebody involved in the development of technology, is to say, oh, that's because we're so good. That's because the Solution Explorer is amazing, and it's just solving all of these problems without people having to file claims. So we are trying to test that theory because an equally plausible explanation is it's horrible. It puts people off filing a claim because they can't figure out their way around it. We don't think that's the case because user testing says the opposite, but we have consulted with stakeholders and we're doing some deeper analytics, and it does seem to be the case that oftentimes just getting that letter, asking for that hearing from the Strata Council is pretty effective at resolving disputes. Or alternatively, people can find out that they're very upset about something, but they don't actually have a legal claim. On the small claims side, here's what we expect this year. I've mentioned that in the last 14 days, we've already had 100 cases. Good news for us because it means people are finding us. We expect to have about a 50% default rate consistent with the court's experience, but an 85% facilitation success rate. That's maybe a bit optimistic, but that's what we're shooting for. And again, these analytics are going to inform our process. So this is a real opportunity for us to use AI, to use machine learning, to use analytics to figure out if certain cases just never settle, or what kinds of things work or what kinds of things don't work. And we're doing some interesting work with the Cyber Justice Lab in Montreal on that, and we've got some SHRC funding for that, which is pretty exciting. I think I've harped on that enough. Okay, beta testing, really quickly, this is the last chunk of beta testing we did before we launched Strata last year, but it's probably the 6th, 7th, or 8th round. And it's really just to validate this idea that rigorous, constant user testing yields decent public sector technology. One of the challenges with public sector technology development is that you don't have any market discipline. You don't have shareholders in some Silicon Valley company driving you to be cutting edge, driving you to make technology that meets people's needs, making sure that you compete with competitors in the industry. Public sectors don't have that. What they have is tax dollars and a massive bias towards inaction. So it's challenging. It's a challenging environment in which these are things that are not good for the development of good technology, in my view. So what do? Well, in my view, you create your own market discipline, and you do that through user testing, constant user testing, because it keeps you accountable. And then you report out on what that user testing says. So I think I've taken, I don't know what time it is. I have a tendency to blabber on. I don't want to take, too much of Lauren's time. Okay, so I think we're okay. There's my contact information. I can also give you my business card with my direct email. But yeah, check out our website and please let me know if you have any questions. And with that, I will pass it over to Lauren. And then do you want to do questions at the end, Brendan? Okay, perfect. So I will attempt not to trip over the cord.
Let's give a big hand for So hi camera, Katrina again. There are some pamphlets and additional information that Shannon's brought, so folks in the room, please feel free to take some as you exit. I'm just going to switch things over to Lauren now, so hang tight. Okay, Lauren, I think we are good. We can see your PowerPoint on the screen, so feel free to get things going and thanks so much.
Perfect. Can you hear me okay?
Yes.
Okay, great. I just added Brandon to the Google Hangout. Brandon, were you going to try something before I start?
No, go for it.
You're good? Okay. Well, thank you so much, everyone, for being here to listen today. I have absolutely no idea how many of you there are in the room there, so hopefully it's a pretty good turnout. I'm sorry I couldn't make it in person. As Shannon mentioned, I'm going to be talking about the Solution Explorer. I'm going to go pretty quickly. Unfortunately, I'm not going to cover off all the points that Shannon mentioned that might be interesting, but please feel free to reach out afterwards if you have any questions or anything. I'm always happy to talk about the Solution Explorer and what it is and how we're doing it. So as Shannon talked about, the Solution Explorer is a seamless end-to-end process that sits up front in the tribunal process for the CRT. It's what people have to go through. Almost everyone that makes a claim to the CRT has to have gone through the Solution Explorer. So there's a few exceptions, and the CRT doesn't want the Solution Explorer to be a barrier for people or to be unnecessarily arduous when it's not appropriate. But the vast majority of people that make it to the Civil Resolution Tribunal and make a claim there have come in through the Solution Explorer. It's a expert system, as Shannon mentioned, with the goal of providing just-in-time guidance, customized for each user. So the focus of it, it's not a legal information system that seeks to educate people on everything they need to know about a particular area of the law, but the goal is to give them the information and resources that they need when they need them to deal with the specific problem or issue that they're having. So one of the ways that I like to explain it, in my mind, it works kind of like a choose your own adventure book that you might have read when you were a kid. So the answer to one question dictates the next question that you see in the system, and so on. So there's no reason that a user can't back up and try a different pathway, try out a different adventure and a different ending, but depending on what answers they give to each question will dictate where they go next in the system. So I could probably skip right past this one, but for those of you that don't know what an expert system is, it's a system that's been programmed using artificial intelligence techniques So for the CRT system, it's not as fancy as artificial intelligence could be. I'm going to show you the nuts and bolts of how we break it down, but essentially it's the process of putting legal information into a system in a logical way so that it can give the users what they need when they need it. The CRT, we've built systems in two main subject areas, which correspond to the jurisdiction that Shannon was talking about. So we have small claims expert systems and then strata property expert systems. I'm not going to be able to talk much about the challenges that were involved in splitting up small claims into a series of systems, but I'm sure you can imagine how difficult it is to try and take something as broad as civil disputes generally, or small claims disputes generally, and then try to hive that off into discrete little systems. So we have a whole philosophy behind that, but want to try and get people the information that they need. We don't know if they're going to go into the right system or the system that we planned that they go into, but our goal is that no matter what system they go into, there's going to be information there that can help them. And where appropriate, we sometimes pass people back and forth between the expert systems to try and help them get into the right system, even if they didn't choose the right one to start with. I'm going to skip over that one. So knowledge engineering. So knowledge engineering is the process that we use when we build our expert system. So it's the process that we go through when we're creating the information, the resources, the tools, everything that goes into the Solution Explorer. In teams that have 3 people in them usually. So the first on the left there is the subject matter expert. And that's a person who is providing the expert knowledge for the system. So that's the person we're essentially trying to stick little suction cups to their head and extract out the information about the area that they are a subject matter in. So often our subject matter experts are lawyers. They aren't always. There's absolutely no requirement that they be a lawyer. They just have to be someone that is very knowledgeable about the area that we're building a system in. We've been fortunate enough to have some of the top lawyers in the province help build our expert systems, particularly in the strata property areas. So we've had some very specialized lawyers who have given hundreds and hundreds and hundreds of hours of their time to act as our subject matter experts for free to help the CRT build these incredible expert systems for users. The second person is the knowledge engineer. And that's someone who, again, is usually a lawyer. Doesn't have to be. Often our knowledge engineers are lawyers just because we found that, generally speaking, a lawyer is able to interact with the subject matter expert and know a bit more about maybe when to challenge them or when to pry a bit further in certain areas, but it's absolutely not a requirement that someone be legally trained in order to be a great knowledge engineer. The knowledge engineer is the person that's sort of looking at the information that comes out of the subject matter expert and acquisition of that information. So asking them the questions or, asking them to elaborate on certain areas or driving the conversation in certain directions. They determine the structure of the content and the pathways, and they're viewing everything that comes out of the subject matter expert and trying to apply a logical, rule-based approach to it. The third person that's in the team creating the content is what we call a content specialist. So this person, they're responsible for technology during these sessions to record all the info that the subject matter expert is telling the knowledge engineer. So they're generally pretty quiet. Sometimes they'll ask if they need clarification, but they are driving our mind mapping tool that we're recording all the information in. They'll also go back to the content in between the sessions with the subject matter expert and the knowledge engineer and do some editing, clean it up, and make sure that located sessions were going as quickly and as efficiently as possible. Almost all of our sessions are done remotely, so these 3 people are almost never sitting in the same room, and technology and teleconferences to hold our sessions. So those 3 people will make up the left-hand column on this slide, the subject matter expert, the knowledge engineer, and content specialist. Once the content's all been created, it goes through the review and approval process that we're building the content for. So in this case, the Civil Resolution Tribunal. This is where somebody from the CRT comes into the process and either approves the content or tells us that there's some issues with the content and we need to go back and make some changes. So as Shannon mentioned, she has 16 part-time tribunal members, so we borrowed a lot of time from those tribunal members to walk them through every single piece of content, piece by piece by piece, to make sure that it had their approval. The little purple person, the extract, transform, and load process. This is somebody in my office who's much more technologically inclined than I am. They're known as an expert system analyst, and they go through the process of translating the content that the knowledge engineering team has created on that into something that our system can understand. So they take our mind maps, they transform them into a program called Visio, and then they load them up into the system that the user sees. And then finally, the fourth step in the process is user testing, and this is really huge for us. We do a lot of user testing. We start with internal user testing when we build content, and that's where we use CRT staff or staff of my office in the Ministry of Justice to essentially get their eyes on every single piece of content. So by this stage, a lot of people have seen this content. There's the people that built it, there were the review and approvers, there were the people that did the extract, transform, and load, and now we've got more people that are going through every single piece of content and making sure that there's no errors. After them, we go to our friends and family testing. This is where we start sending out the link to specific groups of people that haven't seen it before, just to get a few more eyes on it. After that, we start doing public testing. So we'll do closed testing, where we send the link directly to stakeholders. And then after that, we do widespread public open beta testing. At any stage, so our goal, the arrows on the bottom is sort of the happy path of how content would move through these stages. It would start with being created, it would go to the review and approval, go to extract, transform, and load, and then get user testing. In reality, that's not really the process that follows, because we take the results of every single stage of this and every single user test that we do very seriously. So sometimes something will come back in the review and approval process and it'll send us back to the drawing board, or sometimes it'll come up in the user testing and our final stage of open beta testing, and maybe it's something that sends us all the way back to content creation when we realize that we didn't provide enough information about something, or there's a different direction we should have gone. So we definitely spend a lot of time reviewing the information that we get from our user testing, seeing where we can make changes and implementing those changes. So in terms of when the knowledge engineering team is building content, so this is when the knowledge engineer, the subject matter expert, and the content specialist are sitting down together. We use a program called XMind to do this. It's just a free mind mapping program that you can download off the internet. It's nothing fancy, definitely is a very sophisticated piece of software. It really does the trick well for us at allowing us to build these decision trees. So this is essentially what a map would look like. It would be filled in with information, of course, but depending on what pathway a user went down, that would dictate where they went, and so on and so forth, like that. So in the content of a real system, hopefully this writing isn't too small for you there. This is from the loans and debts content that we built for the small claims system. So one question that we might begin with asking, this was from an earlier iteration, so it might not be the exact language that we ended up with, but the first question that we might ask in a system is, are you the borrower, the lender, or did you guarantee the loan? Basic question. Our subject matter experts told us that that's one of the first things that they would need to know from the person that's sitting in front of them with a loans and debts related question. So assuming the person says they're the borrower, our experts then told us that the next question we would ask someone who is a borrower is, what type of debt is it? So this is the process that we go through to figure out what the questions are to ask each person. So if somebody has said that they are the lender, they didn't tell us the borrower, maybe there's a different question that follows after that one. Experts would have told us what that one is too. So one of the really neat things, Shannon was talking about how when a user is going through the Solution Explorer and they come to something like an info resource, they can mark off how many stars they give it, or they can rate it as not helpful. That's data that users can give us directly during their exploration, but we can also learn a lot about people just based on the patterns of explorations that happen in our system. So we're not collecting any personal So I think I'll hold off there. I see we're a bit over time, but I'm more than happy to answer any questions if anybody has anything for me.
I have a question.
Brandon, did you want to? We could
No,
field some
let's
questions.
just do
Okay,
questions.
perfect. Folks online, if you need the question repeated, just type it in or try to speak up for the folks on the online. And Lauren, if you can't hear us, just let us know.
I can hear you. Thanks.
Perfect.
Yeah, it's quite an interesting project and an impressive, I think, an impressive roadmap that you've shown for us, or not roadmap, but rather the development process. I have a question with regards to whether there's been any thought given to, or whether it's happened, open sourcing the code or developer engagement. I know the BC Developers Exchange has been making some good headway with trying to engage with local software, well, with software developers.
Lauren, I'll throw that to you since you work for the ministry and the ministry owns the code.
Yeah,
You're
I'm
welcome.
probably not the right person in my office to answer that question. I know, we're more than willing to, who's interested in using our platform. I don't think the ministry has got to the point of thinking about open sourcing it. But we're interested in talking to anybody who's interested in what we're doing, and I don't know, it could potentially be a future state, but if you have any ideas or anyone to put us in touch with, I'd be happy to chat to someone.
What about, it was mentioned earlier that as the government, we have to consider 100% of the users, whereas a private company might only have to consider a subsection of that. Are there any sort of open APIs or encouragement for private companies to develop private applications based on CRT? Or actually using it?
Lauren, do you want to tackle that or do you want me to?
I think that one might be a better one for you.
Okay, well, not that I know of is the short answer. I mean, there's certain features of all of these kind of ODR platforms that can look pretty similar at times. So, in that sense, I think a lot of it really comes down to user experience. But no, not that I know of. There's certainly, we certainly keep an eye out of in terms of what's out there and do an environmental scan and see what private companies are doing, because it's really good to make sure that you're, again, the market discipline, that you're developing stuff that is at least as good as what's out there in the private sector. But there hasn't been any kind of talk about APIs with private enterprise right now. Talked everybody to death.
Any other questions?
Are there any questions online?
I haven't seen any. Eric has vanished. He's been replaced by Adam.
Eric had to bow out, but
I didn't see any questions online. So let's just assume there aren't. Okay, so thank you very much.
I think Andrew, did you have a question?
Yeah,
Oh,
I can throw one out there just shortly. Is there anything that the CRT needs from either the legal community or the developer community? I mean, some of the questions there, it sounds like there isn't a great fit at this point, but
I think there are opportunities there. Like, one thing to know about our technology, and Brent, sorry, you can chime in here too, but one thing to know about our technology, or the ministry's technology, is that it's not all bespoke. It's built on Salesforce.com. So the idea was to look at what was out there off the shelf, not reinvent the wheel, and customize as little as you can to create what you need. So Salesforce was developed as a customer database management system, as many of you probably know. It wasn't developed for the justice sector, but if you think about a case management system, it's basically something like that, right? A giant database that can store information tied to different fields. And So we've just built the Solution Explorer and the Dispute Resolution Suite to kind of integrate and sit on top of that. But that's an example of where you can get off-the-shelf solutions, and the technology is developed by a number of subcontractors. So I think there is real opportunity. It can be challenging. I know the government procurement process can be a real impediment to that, the way that contracts are typically structured, and maybe I can say this, and Lauren can't because I'm not in government in that way, but I've heard from other jurisdictions too that it's a very old model of procurement usually. The way the government procured this technology was very different. It was using agile software design, a higher degree of accountability, and that made it, I think, easier for everybody to participate. So there's definitely conversations, I think, to be had there. Lauren, do you have anything to add to that?
Nope, thanks.
Yeah, I could probably talk about this more than Lauren can at the ministry, but if you are interested in talking to folks in the ministry, you can certainly put in touch with them, and I'm sure they can give you feedback in a general way, because there's no active procurement process about where this is going. The National Center for State Courts in the States is also trying to work on this issue and try and figure out how to better leverage private companies to provide these kind of technologies, because they've seen a lot of in-house technology development that's gone terribly wrong. And I've seen that too in my travels, where there's like one person in the IT department who knows JavaScript, so they're ready to go, and that's just not enough, right? You need to have a UX person, you need to have a really good expertise that's pretty hard to find in the bundle of skills that people have within courts or tribunals or even government. That's my 2 cents. That's not speaking on behalf of the government of British Columbia.
Just wondering, the other half of the question was what can lawyers do to help? Embarrassed to say, I had no idea this was so cool, and it's very cool, and it's exactly what we needed. So, are there particular areas or subject areas that you have had trouble finding experts in, or how can someone help?
Yeah, for that part of the question, I'll throw it to Lauren, because she's had the difficult job of wrangling experts and getting busy lawyers to volunteer their billable time to this project.
Yeah, I think in terms of the CRT, like any area that we've got a small claims content in right now, or that you think is a gap in the small claims content, if you're taking a look and you notice anything that's missing, we'd definitely be interested in talking to any lawyers that are interested in acting as subject matter experts for us. And that would be, of course, at Shannon's discretion about whether or not the CRT wanted to expand the content at the moment or not. But if there's any area, or even aside from the CRT, the office that I'm in, we're working on building expert systems in a whole range of different areas of the law. So basically, if you see an area of the law that there is an administrative tribunal for, or anything like that you think it would be really great to build a system as the front end for, that's a conversation that we could have. And if you'd be interested in being involved in that, then I think that would be really cool.
Sure. Just a follow-on question on the open API front, and touching about something you raised earlier, but the need for a kind of a robust database of decisions. To what extent is there interest or just openness to opening up the API on the not at the beginning of the process, so not to create kind of private sector systems that would parallel, but rather at the end, so that all of those decisions aren't just available, say, on Canly, but also via something more open like an API?
Yeah, I think that's something we'd look at. Canly was, full disclosure, I sit on the Canly board, so this is
a logical place to start.
This was a decision that was made before I was on the Canly board, but it was, from an access to justice perspective, it's a free service, so it was kind of a no-brainer that it's pushed there. I think for other private sector groups that are interested in looking at the decisions, we kind of have to look at that from a public interest perspective, but I wouldn't say no automatically. I think there's a lot of really interesting applications for that kind of data right now, and some of them may be in the public interest.
Sure.
And sorry, just to build on other ways lawyers can get involved, I think there's part of the challenge of this project is that there are ways for lawyers also to provide services to clients who use the CRT, but it's in a very different model than the one they're used to. And it comes at a time when we talk about unbundling, but we're leery as lawyers about the regulatory model, and we're not quite sure how to do it, and also frankly protect our liability and make sure we're fulfilling our professional obligations. So I think for a lot of the people in the CRTs who come to the CRT, on the small claim side, about at least 70%, maybe as high as 90% of them are unrepresented. On the strata side, they just weren't going anywhere. But these are people who might pay something. They probably won't pay a full retainer for their claims. But for lawyers who can figure out a way to provide a bundle of services, whether that's advice or basic submissions or whatever it is, I think there's an opportunity there. And I think the other way that lawyers can be involved is as advocates for change in the system, and to really encourage our colleagues to think more openly about the way that we give effect to things like the rule of law and procedural fairness. We often tend to think that the status quo is the only way that justice can actually be served, but it's really hard to sometimes widen people's minds, because frankly our whole education and experience is really around this sort of precedent, fairly rigid model, and I think it has to change. So there's some real thought leaders, I think, in the legal profession around that, and they tend to have a lot more credibility because they are lawyers and they can be good advocates for it. So thank you for saying our system is cool. Anytime you do anything in the justice system that's described as cool, it's a special day.
I mean, I'm not a very good, arbiter of cool.
I'll take it. Neither am I, as my kids will have.
Okay, so any other questions from anyone? Yeah.
This is just a general question for Shannon, whether or not you can talk about sort of the future plans of the CRT and whether it's intended to provide assistance to the traditional system to sort of shorten those lineups, or whether it's intended to actually eventually replace that system, or
right. I mean, from the CRT Act, we now have no more jurisdiction. We've taken beyond increasing our monetary threshold to $25,000, but in doing that, even taking claims $5,000 and under out of the provincial court, as I said, that's 40% of their cases. And we've been hearing a lot about the Jordan decision and the wait times for criminal family cases. This is, again, me not talking on behalf of the CRT, but it seems to me there's only kind of a couple ways of doing that. You can either pour millions and millions and millions of dollars into the system, or you can think more strategically about process and proportionality and taking those low-value claims out of the system and freeing up judges, sheriffs, clerks, registry staff, janitorial staff, all of that, so that those judges are not adjudicating $500 claims and they're instead being used where they're most needed, I think has some real value to people in other areas of the law beyond the CRT. So it is both about increasing access to justice for CRT participants, but also thinking about how do you transform the justice system generally, and I think we are playing a little role in that. ODR generally, I don't think we know its limits yet. And I think a lot of people are watching the CRT to see if this could possibly work at all. And that's partly why the data transparency is so important, showing people how it works. And that's not just quantitative data. We also survey people who go through the process, and we ask them questions like, did you feel heard? Did you understand the process? Did you feel like you were treated with respect? Did the technology work for you? Tell us what we can do to improve it. And so it's that quantitative research that I think is also really key. But I think if we are able to prove out the model, then we don't know we don't know the limits yet in terms of where it could be applied. In my own personal perspective, I think family is an obvious area where there might be some way to treat those very emotionally driven cases in a way that's maybe less legalistic, maybe more informal, more collaboratively based. But it'll be interesting to see, and also what we're watching for is making sure watching to see who's using this and who, despite our best efforts, is still having trouble.
Yeah, I'm just wondering, so we mentioned earlier that there aren't other systems really like this in the world, and I can imagine that saying, hey, we've got this idea to do something new and different, and let's use agile methodologies and things like that, must have taken a lot of effort to kind of get into action. So I guess two parts there. One, why? And two, what sort of hurdles were faced in the beginning, and how were those overcome?
Sure. And Lauren, sorry, I realize you might have something to add to that from the ministry's perspective. I know you weren't around back then. You're one of our recent amazing coup hires for the ministry, but from the ministry perspective, did you want to comment on that at all?
Yeah, that's a tough question for me because, like you said, I joined the ministry in spring 2016, and this project, I believe, was ongoing since around 2009 or 2010. So, unfortunately, if Darren Thompson was here, who some of you might have heard speak, he'd be able to comment a lot more than me on some of the hurdles. But I know when they were building creating the legislation, that they started with a really, really, really crazy picture, and it just sort of had to get talked down on some points along the way in order to get it to a state where it was something that would go forward. But
I think
I can't speak to all the hurdles. I know one of the ones that was a bit of a sticking point was a process between the CRT and the finality of CRT decisions and the appeal process to the provincial court, especially in the small claims context. So the way it landed, as Shannon touched on briefly, it landed at essentially a trial de novo in small claims court if somebody's not happy with their CRT decision. So that was one of the hurdles, and I think that wasn't where the minds behind the CRT were going initially, but that's where it landed.
Yeah, I think that's right, Lauren. And there were a number of legislative compromises that happened along the way before my time. So the legislation was passed in 2012. I think it was a brainchild a few years earlier than that, as Lauren says. I was appointed in 2014, but the folks in the DRO have been working on this for years at that point. In particular, really a lot of behind the scenes work, especially. One thing I underestimated when I was appointed was how much of the role would be change management. So I came from an admin law background, not a tech background, not a change management background, and was surprised to find that about half the time I was doing change management work, either building relationships with stakeholders or doing presentations, and I sort of learned as I went. But it is so important because I don't think you can do something like this unless you really take people by the hand and bring them along with you. It's that old saying about if you want to go fast, go alone. If you want to go far, go together. And I think you do have to show people and reassure them that you're not throwing out the baby with the bathwater. You're not upending the rule of law. That you are taking everybody you can into account. That you're listening to folks. So that was a huge challenge, and there was a fair bit of resistance, candidly, from the legal community a few years ago. I think that's largely gone away because I think we've done a lot of collaboration and reassurance, and they've seen, frankly, that it's been working for a year, and nothing's crumbling. There aren't riots on the street or anything. But it's an ongoing dialogue, and I actually think the technology is hard to develop, and I'll tell you, it's really challenging her work, but it's not. I don't think in some ways it's quite as difficult as culture change. I think the culture change and the change management is really hard. But it's happened a lot, and I think also the world has caught up in some ways. So I don't think 10 years ago this would have been possible, but I think the way we engage with our world has changed so much, and cell phone technology is so ubiquitous that it almost becomes kind of so normalized, this idea that this should happen. You talk to groups of members of the public and they're like, wait, you can't do that? This is the first time you can't do that? You have to go line up and figure out where to go and then fill out a bunch of paper. Like it doesn't make sense when you can get anything delivered to your door in 2 days. Right? So anyway, those are hurdles. There will be many more.
Okay, any other questions? All right. So I'm going to just talk and probably not be in the live stream, which I'm okay with. So I'd like to say thank you to Shannon Salter and Lauren Kerr for spending the evening with us. Sounds like there's been a lot of challenges getting the CRT up and going, and it's really cool to hear about somebody in the justice system sort of doing iterations and kind of failing up and basically applying modern approaches to something that's been around since forever. I think there's like a Hamlet, in the Hamlet monologue, there's something about the law's delay. Yes. So it's really cool to hear that, we're kind of maybe now sort of getting around to a point where that's not going to be, hopefully in 10 or 20 years, such a big deal. I would So thank you. We have another meeting coming up in July. We're probably going to be planning those coffee meetings coming up sooner or later. So keep an eye out for that. One last thing I want to mention, because I forgot to mention at the beginning, is we're trying to get up to 100 subscribers on our YouTube channel, because then we get to claim our like vanity URL, which is just like a personal. It just bothers me because we have them all on Twitter and everything, but we don't have the YouTube one. So if you go to bit.ly and then capital VLH-YT, all capital letters, that'll take you to the YouTube channel. Please just click subscribe, and then at some point we'll be able to claim the vanity URL. Okay. I know. So with that, I'd like you to join me in thanking Shannon Salter, Lauren Kerr for joining us, as well as Katrina Leung and Courthouse Libraries, and yourselves for coming out. So thank you, everyone. And we'll put the next event up online. Have a great evening.
Thank you.